Welcome to Hull Estates and Succession Planning, a series of podcasts hosted by Ian Hall and Suzana Popovic-Montag. The podcast you are listening to will provide information and insights into estate planning in Canada. From the offices of Hull & Hull in Toronto, here are Ian and Suzana.
Hi, and welcome to Hull on Estate and Succession Planning. You're listening to episode 187 of our podcast on Tuesday, November 17th, 2009.
Hi, Suzana.
Hi there, Ian. How are you?
I'm great, and yourself?
Well, thank you.
Good. We're back in a roll. Second one since your layoff of what seemed like an interminable amount, no doubt to the audience, of me doing some solo podcasting. All right, coming back to the duties and obligations of a power of attorney. We talked the last podcast at the end of it about the accounting obligations and your great analogy about paying it back. And if you mess up, you're going to have to pay it back. The next sort of topic that we want to sort of dovetail into it, of what our clients are going to expect on their obligations, is duty to account. And the next one, of course, is the question of confidentiality.
And it really is a matter of making sure that you are keeping the person's affairs confidential. Even though you're acting as the replacement or their substitute decision maker, you've got to maintain that air of secrecy, in a sense, in terms of their particular affairs. I'm not saying secret from others, but secret from people who could possibly compromise that confidentiality.
And that confidentiality is unwavering. And one of the things that I find, I see clients who are obligated under the Ontario Act, you're obligated to get a copy of the will. If you take over an incapable's affairs, you're obligated to look at the will in Ontario, because you need to know what the expectations are in distribution. So you don't, if you can avoid it, you can accommodate the gifting in the will as well as looking after the individual, although looking after the individual is paramount. But this whole question of what happens then when an attorney looks at the will, and what do they do with that information, is a tough problem, and one that underscores the need for confidentiality, obviously.
And we've seen instances, certainly in our experience, where we've had beneficiaries asked to see copies of the will of the attorney, and they come to us seeking the advice as to what they should do in those circumstances, because it's a very difficult decision.
And unquestionably, certainly in Ontario, it's no talking, no disclosing the provisions of the will, but there may have to be some behavior modification. For example, if the will allows for a gift of the cottage to my niece Betty, and the incapable individual has lots of money. So it's not a question of needing the cottage to sell the cottage to make ends meet. It's a question of, maybe to the extent that the attorney can accommodate that request and accommodate that wish, they may want to. And so they may want to drill down on the cash, preserve the cottage, because they know the cottage is supposed to go to the niece. That brings with it its own tensions, though.
For sure.
Because those who are going to receive the cash might say, well, why didn't you sell the cottage? And those are the kinds of discussions that we need to walk through with our clients, balancing interests and all of that sort of stuff in that scenario, with the paramount concern, as always, the cases keep coming back to it, the Act keeps coming back to it, is what is best for the incapable.
And that situation in particular is a difficult one, Ian, because if you're faced with this duty of confidentiality and you have an incapable person who, for instance, has got to move into a home, then beneficiaries or family members might be questioning an attorney as to why a cottage is being maintained in Muskoka if in fact that individual can never benefit from it. So you're walking sort of a fine line there. Yes. in your duties.
And the answer would be, come see a good lawyer, because that's not one that we could solve necessarily on a podcast. And a lot will depend on circumstances and so on. We're not trying to avoid the answer. It's just that the truth is that a court's going to sit back and look at all of the factors before they're going to come down hard one way or another.
That's for sure.
Should a beneficiary complain. So thanks so much. Welcome back.
Thank you, Ian. Looking forward to it.
Appreciate that.
Bye.
You have been listening to Hull on Estates and Succession Planning by Ian Hall and Suzana Popovic-Montag. The podcast that you've been listening to has been provided as an information service. It is a summary of current issues in estates and estate planning. It is not legal advice, and you're reminded to always speak with a legal professional regarding your specific circumstance. To listen to other Hull & Hull podcasts or leave any questions or comments, please visit our website at hullestatemediation.com.